We are on the record.
Case D 577473. Sobczyk, Osborne, counsel, your appearances and your bar numbers.
Good afternoon, Your Honor. Petitioner bar number 8846, appearing on behalf of the plaintiff, Christine Sobczyk, who is present, and she is standing to my right.
Okay.
Good afternoon, Your Honor. David Jacks, bar number 12409, representing Aaron Osborne, who is to my left, and I have with me Jamie Knopf. She's a law clerk at my office.
Any procedural matters before we begin? Any rules to be invoked?
Yes, Your Honor.
Yes.
Exclusionary rule.
If you are testifying witness at this trial, we ask that you wait outside until you're ready to be called for your testimony. If you're testifying in this trial. Any other rules? Any housekeeping matters?
Yes, Your Honor.
Mr. Jacks?
Well, maybe we can let Amity go if we can address that. too.
Oh, I figured you guys talked about that motion to quash subpoena.
We
Yes.
did,
It's come-
and,
Good afternoon, Amity Dorman, Chief Deputy District Attorney, bar number 9316, on behalf of the Department of Family Services.
Yeah.
We were actually served, just a brief history, we were served a subpoena for the person most knowledgeable. We've released records to this court a couple of times, and there's.
We've
more
always had
than-
them, yeah.
Yeah, there's more than 4 case agents, so we've got a supervisor, we've got a case agent no longer employed.
Okay.
We've got a case agent who's now on emergency response and is off Monday, Tuesday, she
Yeah.
works an overnight shift. A forensic interviewer, I didn't even look up who did the forensic interview.
Okay.
So it was quite a quandary. What we discussed
Yeah.
was that the supervisor, who's now also been promoted, she's not even a supervisor anymore.
Okay.
But should you wish to have testimony from CPS, she might be the most logical person.
Okay.
She's actually out until Thursday.
Okay.
So
We'll work with that.
Yeah, I have
Very
no
good.
way to contact the person who no longer works for DFS.
Given the nature of this trial, I think maybe 2.5 days might not be enough, so we'll plug along,
Okay.
and we'll keep that in mind. Too soon to tell. I'm pretty booked up, but
Yeah.
we'll try to find the next couple of half days available coming up, so we'll start making a reservation of dates. We'll give you well adequate notice to your supervisor. What's her name?
Her name's Cheryl, and she's now the head
Oh, yeah,
of
I
the
know.
Children's Advocacy Center.
Okay.
But as I was telling Patricia,
Cheryl
she's
Cooley.
mostly administrative now.
Yes.
So she should, other than the fact that
She
she's
should
on
be
vacation,
flexible. Okay.
She works 8 to 5, Monday through Friday, that type of thing.
All right. So you know my secretary, Susanna. She'll
I do.
coordinate everything with all the
Yeah.
attorneys.
Yeah.
She brought that to my attention. I was like, oh, okay, I see this. Let's
Yeah.
just serve it on the attorneys downstairs, see what they want to do, and
Yeah.
let them talk.
Yeah.
And I appreciate you coming up
Of
and
course,
resolving
yeah,
it.
Yeah.
Um,
And we do have the hearing on the July 24th, if we can just vacate that.
Vacate July 24th.
Yeah, we all resolved.
So we all agree Cheryl Cooley is the one that's going to be coming to
Sounds like
represent
it, yes, absolutely.
DFS if when we get to their part of testimony. We'll give well advance notice. We'll give them time to know when they're going to be, and when they come in, they're sort of in and out because I know they're busy schedules. So
Yeah, definitely.
appreciate it. We'll
Appreciate it
coordinate.
very much.
All right, thank you.
Okay, good to see you.
Here, tell her I said hi.
All right, so we took care of Miss Dorman's motion. It's moot now. It's all resolved and worked out. Anything else? I do have your pretrial memorandum. Okay, I have
Did you?
notebooks there.
Oh,
And what else?
oh, I was just gonna, they were supposed to be sent down last week, I just wanna make sure. Did you get notebooks?
There's a
from
box of notebooks here.
us? Oh, okay, cool.
Okay,
What is that?
get my trial notes up.
Oh, yeah. Well, Stephanie Holland, and I'll make an offer of proof to the court. Christina, the plaintiff has reached out to Stephanie Holland's office as early as April 22nd and as late as June 7th. Yeah, June 7th.
The letter that we recently, the
Yeah.
update letter, I
Yeah.
seen that too.
And the concern is, and apparently Mr. Jackson and I were speaking outside, and we wanted to have Stephanie, and this is what the court had ordered too, is that Stephanie Holland was going to perform the reunification, and now we're being told, we don't know any of the educational background or the work experience for Dr. Deepa, and that's who would be performing this reunification, and under these circumstances.
That's a new name, Dr. Deepa.
Yeah, and I'm really not trying to be difficult
And
at
how
all.
did his name, his or her name come up?
Well, that's the,
I on my
Sure.
presentation.
Sorry,
Yeah.
Dave.
Not a problem. All right, so what we did, Your Honor, is as of the April 3rd hearing, it was ordered that Family Reunification Service, we would find someone to go ahead and start the reunification process using the court chart, the court list. So we did that. We reached out to Stephanie Holland's office. We got back this release that says the Family Court Reunification Services Agreement and Informed Consent. I saw it said Dr. Stephanie Holland, so I just sent it over. I didn't even look at it really. I didn't.
Yeah.
I didn't. I just like, this is good, it's from Holland's office. And then it came back after this last hearing, the May hearing. It was pointed out that it was actually Dr. Deepa is actually going to do that. So what I did is I reached out to Stephanie Holland's office only was a few days ago.
Yeah.
It was last week, and said, look, is there any possible way you can change this out to be Dr. Holland herself? Because that's who we both, we know her credentials, we know her stuff. I don't know anything about this. Only thing I was told by their office was that Dr. Deepa has done forensic stuff before. Dr. Holland's comfortable with them, and so that is who she wants to do it, and she works under the supervision of Dr. Stephanie Holland. I asked if there was any possibility of changing that, and they said because Dad has Medicaid and not paying cash $250 an hour, that Dr. Deepa is the only way that it'll happen under
On Medicaid?
through Medicaid.
Yeah, I'd probably go down that route. Otherwise, reunification can be $250 an hour.
I understand that, but the only concern I have, and this is it's a difficult case, but it's not, if that makes sense to Your Honor. But again, I don't know any, with all due respect.
I don't
yeah,
know
go.
either, but
We can request that the CV.
be at least disclosed to both of us when we agree to it?
Yes.
Because I brought it just in case, but the thing is what the problem I'm having still, Your Honor, is that you ordered reunification in April. My client hasn't physically
I'm
seen
aware.
the child since August, even on Skype since September 23rd.
Yes.
It's almost an entire year, a quarter of this child's life now. How much further are we going to keep?
Well,
okay.
So it's like, look, this is coming out of Stephanie Holland's office. She's obviously going to have some sort of quality control on it because it's her name on the line. And so I was like, look, it's still a doctor. She's vetted them, obviously, to be able to work under her. She says right here, Dr. Depa works under the supervision of Stephanie Holland. So if it became too much or something was too irregular, I'm sure Stephanie would step in or at least be able to be consulted with.
Are they in the same office?
They are.
They're in the same office.
well, and that was my concern, and I understand why Mr. Jackson didn't want to continue the trial, but if the court will notice is on the third amended witness list that I filed, I actually named Stephanie Holland because my thought in doing that was, you know what, let's see how the reunification is going, and she could advise the court of any hiccups or any issues that she had concerns with. And so I wanted this, that's why I named her.
I think the purpose of why we're having this conversation now is to determine if reunification will continue while we are in trial.
Because I'm sure that you're not going to run this day to day to day to day after you.
At the very least, I would suggest that the parties sign up and then go get the CV. And if there's any issues, would still be probably in the middle of this trial.
Okay, and then.
So I'll direct both parties to sign up with Dr. Deepa. It works in the same office as Dr. Stephanie Holland. I presume that they are credentialed. Second of all, very, very difficult to get reunification therapists where Medicaid will pay for it. And fortunate enough to have Dr. Holland being in the same office. So she's going to, I guess, monitor Dr. Deepa doing the reunification, the confidential therapy, obviously, and then they'll report back to sessions attended and all that. We'll just at least have the parties sign up and let them become aware of, and you can get the CV and you can sign up. And I just don't know when this trial will finish, obviously, but something like this, typical with a number of witnesses, it could run into 6 half days, possibly 5, 6 half
And we'll
days.
try and be concise, and we've had some issues with,
Yeah.
I'll address that in a minute if you don't mind, but another thing that we wanted revision in, and I don't know, David, if you spoke to Dr. Holland's office in this regard, is the way it's worded, it doesn't allow for Dr. Deepa or Dr. Holland to take evidence from both parties, the way it's worded, and also the issue was that the court ordered it, actually, that Kelly Campbell actually be able to speak to Dr. Hall and Dr. Diva, and that they coordinate their efforts with the reunification with Kelly Campbell. So, and that's not in there either, and that's our concern, is we don't want to get like, okay, we're started, now we don't need to talk to Kelly Campbell, when she's had an ongoing.
We've objected since April for her even seeing the child again. She has a very firm, she does not want my client to ever have any contact with him again. And like I said, I promised that I would have my day with her. Her stance is so hard against him that there's no possibility of any kind of reconciliation or reunification with Kelly Campbell. That's one of my things here. We've been asking for a new therapist. We never agreed to it in the first place, nor her extreme position, given the fact she's never so much as spoken with me.
Okay.
In that regard, Your Honor, I would note that the court in New York provided her with sole legal custody, and we have, well, let me finish, so I can give the court a background, and she doesn't just hear your side, is also she advised in the spring of 2018 last year, before August, when Kelly Campbell said no more contact, she told Aaron, hey look, this kid's acting funny, I don't know what's going on, I'm taking her to a therapist. He had knowledge of it.
No, we
So
didn't.
it's really, and the evidence is going to prove that. And so he's saying no, that's what he's saying, just so it's on the record. She absolutely, on June 11th and June 13th, there are emails that we'll ask the court to look at in here. Where
I tell you what, it's premature at this point, number one. Number two, we're don't want to cross into muddy waters, because that's their ethical responsibility. Counselors, therapists, psychologists, they have to follow their own code of ethics. So if Dr. Holland, as a psychologist, says that we may need to talk to Ms. Campbell, otherwise it's malpractice if we don't talk to Ms. Campbell and get as much information, or we can talk to Ms. Campbell and take whatever information we want of it. I mean, it could also, now they're not doing it forensically, that office is for treatment.
Correct.
But can you, anticipate, it can go either way, either that it will be helpful, or they're going to say that this Ms. Campbell totally missed the boat. So you're opening up,
The thing is,
how that, but is it going to, you don't think Dr. Holland, after working for the court for over longer than I've been a judge, can't figure this stuff out when they see when they talk to Ms. Campbell? I think I anticipate that they will, because it would be their own malpractice maybe not to talk and get as much information. I could be absolutely wrong, because I am not a counselor or psychologist. I do know that any counselor, MFT, LCSW, what are the other ones? Licensed clinical, MFT, marriage, family therapy. Usually, and LADCs, their motto is do no harm, obviously. So they have to follow their code of ethics and let that play itself out, and then you leave it to Dr. Holland, and you can make inquiry with her what her plans are if she wants to get any records from Campbell. But there are existing records at this point. If it's malpractice to them not to get those records and work in a vacuum, the attorneys and the judge don't get to choose. They have to follow their code of ethics. So feel free, you two can write her a joint letter and ask them, how does that work? Do you plan on talking to Campbell? Judges can't interfere with their own, how they proceed with that, obviously. And then I'm not going to say you're opening up a can of worms there, but who knows, if Holland chooses not to talk to Campbell, let her say that's in my professional opinion, we don't need that information. We're not and let anything bias us in our work. The other possibility is Holland will say, well, we talked to Campbell and she's not credible at all, and I don't know what she did, and I've been a forensic for like 30 years and I've never seen anything like this. And so, you can open the door on that one, but it's inevitable. So go write a joint letter, or if you want to subpoena Holland or DEPA for a trial about their ethics and stuff, I'm open to it. So, but they charge to come to court, I'll tell you that, very expensive. If you lawyers want to send them a joint letter and say, how do you want to proceed? Obviously, yeah, you as the lawyer, you can argue for it, but we can't violate any of their ethics or their,
Of course not.
yeah. And of course, I absolutely don't want to disturb the arrangement because Medicaid's paying for this, and it is for treatment, not for litigation purposes. So you can see I'm sitting on one side or the other. I'm just saying, let them do their job. And who knows how it's going to play out. Okay? Anything else before we begin the trial?
Yes,
We could do you do?
Yes, Your Honor.
Okay, go ahead, Mr. Jacks.
A lot of the stuff that was given to me, I will be screaming
Objections?
objection McMonagle all day long. I need to have a ruling on as to that. The reason why is there were 2 prior court orders from a New York court dealing with custody and as well as
What?
everything in the
We are in Nevada. Nevada law applies.
correct. But,
Okay.
and so, as such, Your Honor, we still have being McMonagle applying as well. Anything prior to April 19, 2018, Your Honor, should be precluded pursuant to McMonagle unless there is some exception. And
How about the application of Castle versus Simmons? Castle versus Simmons involved, you're aware of the case? Domestic violence, and then if the court wasn't aware because they didn't do a trial, then,
but the court was made aware in the prior courts because you see throughout all of the documents that everybody in the world's been made aware of.
was the order in New York litigated like a trial?
I think it was settled actually between the parties, was it not?
It started out in a family court like this.
Yeah.
Apparently back there, when there is domestic violence and other issues, they transfer it to a special court
Thank you.
to deal with that. So
Okay.
whether it was litigated, whether it was a trial, I don't believe so. Yeah, but, and the reason, and I know Mr. Jacks likes to jump up and down, but the reason that this is placed in there, and the court's gonna rule as it will, I'd rather have it in there and not use it than.
McMonagle is still good law, but it was later slightly modified by Castle v. Simmons.
But the reason it's in there, Your Honor, is because Mr. Jacks had brought up some things in his client had brought up some things in his pleading, and it's like, okay, if you
Are we
wanna bring that up.
Is there a change of custody being sought out in this trial?
Yes, Your Honor.
A party seeking to change custody may introduce evidence of domestic violence if he or she or the district court was unaware of the existence or extent of the conduct when the prior custody order was entered.
And both were aware.
They
This
were
court
both
wasn't.
aware.
But
This court didn't preside over
And
it.
this court has made a decision.
I am unaware because I came after the fact.
So anything after the fact would be applicable, nothing beforehand. So anything
Well,
before,
if I'm unaware, then they're allowed to introduce it.
Your Honor, we're basically going to be relitigating the entire case all over everything that happened in New York then.
She can't look at it in a vacuum. I mean, you have to give her some tools.
But we have to follow Castle v. Simmons and McMonagle. That's just the holding. Let me see if it says anything more significantly. It is a custody modification.
Well, Mom is
So,
wanting no
who is
custody,
asking for the
no,
custody
so-
modification? Is it Mom?
It's Dad.
Well,
She
and
already
Mom.
has sole legal and sole
Oh
physical.
boy, yeah, because it says it only applies to the moving party if a moving party wants to change custody. So in Castle v. Simmons, I'm assuming one of the parents wanted to modify custody and they wanted to show there was previous DV in the past.
So that
Here,
can't
Your
just
Honor,
cut
we have-
one way.
But here we have a case where my client was given visitation of 10 days. Under our law, she would have had primary physical custody, my client would have had visitation.
I get that, yeah.
Okay. Now, from there, they moved for absolutely no custody, no time for my client. That's the reason why we're here today, is because of the allegations of the sexual abuse. Now, we, on the other hand, have filed our motion pending alienation, saying no, that it meets Ellis versus Carucci, and therefore it should be joint physical custody. We're asking for that because we're not saying Mom, the child shouldn't be with
Okay.
Mom, but the thing is we
This
need to
stuff
make
you
sure
want to keep out. What are we talking about? DV?
DV, statutory rape charge,
Right.
DUI, what else is
This
that?
happened when he was 18, 19 years old, and okay,
Not
again,
that long ago.
Then I would go
he's
to
27.
relevance. Although it says, let me read this section of
26.
Castle. Our McMonagle and Hopper decisions include broad language suggesting that important facts relevant to the child's best interest if they existed at the time of the prior custody determination, cannot be introduced at a later proceeding, even if these facts were unknown to one of the parties or the court when the prior determination was made. Nevertheless, this court has never expressly determined whether generalized principles underlying the res judicata doctrine should prohibit parties from introducing evidence of DV that was previously considered by the court in a custody matter. Although the doctrine of res judicata, as applied to changed circumstances doctrine, promotes finality and therefore stability in child custody cases, it should not be used to preclude the parties from introducing evidence of DV that was unknown to a party or to the court when the prior custody determination was made. We recognize this, and then it goes to talk about the Abel case and all that. We conclude that the changed circumstances doctrine does not apply when a party seeking to change custody, and they're both seeking to change custody, attempts to introduce evidence of DV if the moving party, could be either one of them, or the court was unaware of the existence or the extent of the conduct when the court rendered its prior custody decision. So what are we talking about? When these two were together, that mom didn't know about dad's stuff about dad, and dad didn't know stuff about mom?
No, what we're saying is they both knew about everything that was made. Allegations were made all over in New York, and that is settled at that point, which is now everything's at that point, unless they have something new that would be the exception under Castle v. Simmons.
How much did the New York judge know?
That
You
we
know,
don't
that's a
know,
good
Your Honor.
question.
So we don't know.
But the thing is it's
And-
assumed that they would know,
and-
because they were
and-
in a
Right.
special court
Your
just
Honor,
for that.
there seems to be this misconception that my client is trying to terminate parental rights. That's not true. She just wants to do what's in this child's best interest, and so she has asked, at least at this time, that the visitation, and that's based upon Kelly Campbell's suggestion. Ponzo also said, you know, if that child is in the room with, to pick her up and run,
Okay.
he's gonna testify to that. So that's all. She's not trying to. I
It
keep
sounds
hearing
very
this.
commonsensical, so you're saying, why are we having this trial if we could just proceed with reunification and see where that takes with that? Dad obviously takes a different view. He
No, Your
says,
Honor, we actually don't. They're saying absolutely no visitation whatsoever. Matter of fact,
That's
it's not
Miss
giving
Kelly
any.
Campbell.
It doesn't matter.
I
They're
see. I
saying
thought
absolutely
about
not.
this case before I was going to go to trial today. I've been giving it some thought, and I was wondering, no matter what the outcome would be, it's not a termination, correct? So Ms. Marr,
Correct.
you kind of hit the head on the nail on that one. Hit the nail on the head on that one.
It's okay. It's Monday.
And
So it's just a matter of where we stop, is either at visitation or joint physical custody as for the time with dad, based on
Correct.
whether or not their reunification schedule. how
I would
best
think
to treat
Dad's
the child,
position was that
all stuff.
mom's motives and everything to make these very, very serious accusations obviously would be enough to say that she hasn't. I mean, your goal at trial is to discredit mom, obviously, and credibility, and say that because you've done this, that he would get 50-50 custody or even primary custody of the child.
He doesn't believe it's in the child's best interest for primary, Your Honor. He thinks that joint physical
Joint is the
custody
best.
is in the child's best
And
interest.
I hate to throw the monkey wrench in, but I will.
Mom would be willing to go with primary, then
She
reunification.
already has it. She has sole legal and sole physical. That's
She
what
does.
they gave her in New York. But
Yes.
Where is it?
But under
I
our
looked
law,
at it.
it's not the same.
Well, I know, and
Okay.
that's a problem. But if I may, Your Honor, I spoke to.
Are we off base here because we're doing either a Truex or a Ellis versus Carucci? You lawyers know which way you're going down? It sounds like you actually have primary on paper, and Dad was to have, and Dad was going to remain in New York and get his 10-day visitation
Yeah.
or wherever it
And
was.
she didn't have
And
a
Mom
problem
has
with
primary. We're talking about Ellis versus Carucci. Material changes circumstances affecting the welfare of the child, such that a modification would be in the child's best interest to give Dad 50-50.
That was
Dad's position would be Mom made up stuff about him,
Tons of
okay,
it.
and therefore that affects the child
And
and
he's moved
affecting
here as
that.
well.
To escape
Um,
the investigation.
No, that's.
okay, I follow the analysis, so,
Your
and
Honor,
that's
may
why I
I-
said it for trial.
Yes, Your Honor.
I-
We believe it's correct under Ellis.
Alright,
Okay.
so on the McMonigal issues, I can't look at all the exhibits all at once, but we cross that bridge every time they try to introduce it. They may not introduce it, but if they do, well, there, you could just say objection, McMonigal, Castle v. Simmons. You have any indications that it was discussed or any of the court papers in New York? pointed out to me, otherwise I have to, this is unusual, huh? We weren't, the New York judge was on the earlier stages of this case,
Yeah.
and then it resulted in a custody order, so
Your,
we'll get there when we get there.
And
there's
Your
been
Honor,
two
if I
orders,
may.
not just one, we've got two.
Right.
There's one in January 12th of 2017 that was done by the parties, and then it was gone back on a petition.
I'll tell you what, you know, most
Another
judges,
one.
I think, take a liberal reading of Castle v. Simmons. It says, we're talking about best interest of the child, safety, well-being, and all that, better to err on the side of caution, and give that kind of liberality, let the evidence in. We'll talk about remoteness in time, we'll sort it out, and if that had
Goes
anything to
away.
do with his parenting skills, etc., about, you know, and, I mean, I get things like objection, bad character evidence, well, they do apply in civil cases as well, so you better brush up on your, NRCP, your,
404.
or chapter title 50
Yeah.
and 47 evidence. Okay.
There is one last thing, Your Honor,
Alright.
in attempting to get the request for
How many
audio
dates?
video
Day 3, day 4.
acknowledgements executed, I spoke to, and as an officer of the court, this is what I was told. There's a detective, Rita Ruffin, in Buffalo, New York, and R.T. Williams at the desk told me that I was unable to speak to Rita Ruffin
Because
she was in court in New York at the time testifying. But she did tell me, I said, well, you know, can you at least tell me whether or not there's an investigation, open, closed, what's going on back there? And she told me that there is an open investigation. That's what I was told.
it's hearsay, I know that.
We
I
don't know
anticipated
anything about
that.
policies either.
Well, I know, but
You
I'm.
need, because if this, you think this is critical to your case, you need
I do,
time.
I do.
Well, you probably have the time because we'll have today, we'll have tomorrow, and we'll have a day 3 or 4, and
Okay.
I'm like super booked right now, but you get high priority. So any dates we offer, we have to have you, both of you lawyers say yes, we're available, or cancel your depositions and come to court and do my trial. Here, it's priority. And if you need the detective,
Ruffin.
Ruffin, they could testify by video, raise their right hand, I can see them right there. So they're just mindful, they're 3 hours ahead in Buffalo,
Yeah,
New York.
yeah.
Okay, so you'll have time to get with them, and
It's-
only thing is, was she named prior as a witness?
The PMK was, for the Buffalo Police Department, and I am told that
Okay,
she's the PMK.
You were able to finally track down,
It's like
As her
between the
assigned.
time difference and my schedule and their schedule, it's like
gotcha.
an act of God.
Do you have any objections? This is gonna be down the road, this detective testifying.
Just testify, that's fine.
I appreciate that. Okay. So that's not gonna be for day 1, day 2. Obviously, we're
Okay.
still working on that one. And then let us know, cause we start at 1:30, it'll be 4:30 their time.
Yeah.
Okay.
And the R.T. Williams was very receptive, and she gave me a wealth of information.
Okay.
And I said, look, you know, we'll have her start, we'll get her in and out of there, because I know she's got a lot going on back in or Buffalo.
So it was
wherever.
Rita Williams?
Rita Ruffin,
Oh, Rita Ruffin, and it was R.T. Williams in that same office.
yeah.
Detective Rita Ruffin will be allowed to testify via video conference when her availability is made and based on our trial schedule.
Okay.
Okay. And if she has any reports, deuces take them or something like that, both of you lawyers will get those reports. Okay. Any other matters?
Mr. Jacks?
Okay, so let's finally get to opening statements. If you want to do opening statements.
Thank you.
I'll reserve mine until not case in chief, Your Honor.
You want to do yours right in the beginning of your case in chief.
I do.
Interesting, okay.
I'll try to be brief.
Okay.
The court's already noted the unusual nature of this case. You have somebody that had, according to New York law, sole legal and sole physical custody when she came out here. The evidence is going to show that mom, and I'll just refer to them as mom and dad for purposes of simplicity, mom already had that award from the court in New York, and she had been taking the child returning to New York with the child, and the evidence is going to show she's very flexible as far as that visitation, trying to coordinate airfare. She was responsible for that. She didn't have an issue. Mom is very close to her parents and recognizes, and she'll testify to this, she recognizes the importance of a child having both parents in she's life. And so she wanted that. She wanted that intact family unit. She doesn't even want to be here, but I tell you what she does want. And I know what you want, Your Honor, and I know what I want, and presumably Mr. Jacks. We want what's in this child's best interest. That's all we want. And, I said before that this is a difficult case, but it's not. And I came to the resolution that it's not difficult. And the whole reason, and this stems back, people always ask me, well, why did you want to be a lawyer? Did you always know that you wanted to be a lawyer? And I thought about that. This is a really important question. And I thought, well, it all goes back to when I was in the 7th grade. And I grew up in a different era where you respected your elders. You didn't dare speak out, particularly against a teacher. And this particular day, my math teacher was really treating a fellow pupil unfairly. And I raised my hand and I stood up and I said, Mr. Kelly, and I can't remember what I said, but expressing my concern for the way a fellow pupil was being treated. And he looked at me and he had those dark rimmed glasses on. He put them down his nose. I caught him off guard. He had bright red hair and he said, what are you, her lawyer? And I said, you know what, I never thought of it like that, but it's just an overwhelming urge to try and help people that are unable to speak for themselves. And this isn't even about Mom as much as it is the child. And what do we have here? We have a 3-year-old little girl, okay? She can't sit at the witness stand and tell Your Honor, this is what happened, and she can't even tell a social worker with detail as far as she doesn't have the tools yet. She's a child. She's not far removed from a toddler. I think toddlers are between 2 and 4. She just turned 4 years of age. And when this happened, it was a year ago. And I tell you one thing, I externed at the DA's office also because I wanted to work there after law school and watched a rape trial, and every victim is different. When years pass and they're put on the stand, sometimes the jury will say, well, you're not being emotional enough. But I can tell you one thing is that this child, and Kelly Kendall is going to testify, that she's adamant. I mean, Mr. Jacks even said she's adamant that something happened to this little girl, Charlotte. Something definitely happened. And Mr. Jacks is going to cross-examine her and say, the regression of potty training, could that be based upon any other reading? But you have far more than that, Your Honor. Far more. Okay, given I wish she could speak. We wouldn't probably even be standing here. The investigation would have either been ongoing with charges, or it just would be a different story. But we have somebody that needs our help, all of us. And we need to, that's why we're here. That you're going to make a ruling. And it's more than that. It's a child that is coming back from Dad's, and she didn't even know. She's like, what's going on? This started like in April or the spring of last year. She's like, what's going on with her? She's coming back. She's saying how she hates Dad, how he gives her naked hugs, how they watch naked movies, how she doing inappropriate gestures, pulling her panties aside and touching herself inappropriately. Behavior which isn't just, who could teach a child that? That's something that's learned from conduct, from behavior. And Mom just, she just wants what every mother wants. And that's for the child to be protected if something's going on, and she believes it is, based upon things that happened in the past, the way Dad has applied, was it diaper cream, and inside, and my pre-trial was wrong, it wasn't around, it was inside of her. But now things are coming together for Mom. She's like, I mean, who wants to believe that? Nobody wants to believe that. We don't, it's aberrant behavior, and it's harmful for a child. I couldn't even imagine being a young child and going through that. I couldn't imagine. I would shut down too. And the CPS is gonna, they did one investigation. They did an investigation. They had one session with her, is what I'm informed, and it was a male. Charlotte takes males for the most part. It takes a lot for her to open up now. And again, I can't stress this enough. Mom just wants what's best for this child. Kelly Campbell's going to get on the stand, and she's going to testify about how she regresses and how she has certain trigger words. When she hears her last name of Osborne, she freaks out. So something happened. She can't tell us directly, but she's telling us through her behavior. Okay. Now it looked. I have the actual photographs. This is the original, and Kelly Campbell did some sort of therapy where they color and color where Daddy touched you. Okay. And this was the first one. And it's very...
Objection, Your Honor, she's showing you evidence.
Okay, well, it's very clear, okay? It's very clear that the vaginal portion of the stick, or the figure, is colored in, as well as the feet. And then, where does Daddy kiss you? And one of the breasts is colored, and then the vaginal
Objection,
area
she's
again.
still describing it.
Okay, well, I'm just going to tell you that's what the evidence is going to show.
We'll get to the photographs
Yeah.
when Ms. Campbell gets on the
Okay,
stand.
yeah. This is what the evidence is going to show. And it's not just like, oh, she had a regression with her potty training, which, sometimes happens, but it's the extent of it, Your Honor. It's that coupled with the pictures the child's drawing. It's that coupled with the fact she'll knock over the computer to avoid Skyping. I mean, she's terrified. She's absolutely terrified. And we are asking this court, we're going to present the case, and it's not easy because you know what? In most of these cases, you usually have a conviction, or you have CPS, or something of that nature. But here we have a jurisdictional quandary, okay? This happened, that we allege, it happened in New York. The Henderson officers, who will be here tomorrow, are going to testify, hey, look, we've been reaching out to New York. We can't do anything here in Nevada. We don't have jurisdiction. We get it. But New York now, it's like, well, Dad moved. That's pretty convenient, but he moved. So now, but I'm still told that there's an investigation back there. So CPS, I mean, everybody's passing the buck on this one. The tender age of the child. And sometimes, when I thought about how I could present this case and make it palatable for Your Honor, and is by comparing it to this. In the 16th century, 17th century, at one time, and we all know this, we thought our world, the earth, was flat. Convinced of it. Christopher Columbus, in his diaries, even wrote, I'm having difficulty getting men to come with me on my sea voyages because they're terrified they're going to fall over the edge of the earth and perish. Okay? And it wasn't until later on that the Greek astronomers in Alexandria said, wait a minute, the way the sun's lining up with the moon, there's something more to this earth being flat stuff. We believe it's a sphere. And of course they're right. So, similar to that situation, we shouldn't be so quick to conclude just because our child can't specifically tell us, because she's shutting down. She regresses. She has trigger words and phrases. But we shouldn't shut this down and just think that, like they once believed the earth is flat, that this didn't happen. It's not fair to this child. We need to hear, and I know the courts, obviously, that's why we're in trial, but there's more to it than that. This earth is not flat here. This happened to this child. Something happened. We're told it's sexual in nature. It's very concerning. And I don't know whether it was actual penetration or not. We won't know because Dad, when that specific visit in August, didn't tell Mom about the hurting pee-pee until after 24 hours. So by the time Grandma took it, she was there in New York to pick up the child, she took her to a medical facility, and there was nothing that they could do at that point. Something happened. You're going to hear from Christina, the mom, about now looking back, it's like, wait a minute, he you know, the cream inside of the vagina, putting the child on your lap in the bathtub while you're completely naked, sleeping naked with your child. You're a man, I would submit that's not healthy and that's not normal, and that's part of this aberrant sexual behavior. You're also going to hear about the fact that they want to poo-poo the statutory rape charge, okay? Sweep it on, oh, that's nothing, he was a minor. So he knew the girl was 14 or younger because he dated her older sister. He knew the tender age of that child. It didn't matter to him. Behavior like this, unfortunately, it doesn't stop, and it continues, and it's scary. Actually, it's pretty scary. But we're just here. Mom isn't here. She has their relationship is over. She's not here, you know, as a grudge, or she had nothing to lose. She's here to protect Charlotte. That's why we're here, and I think you're going to find the evidence is overwhelming that this is a pretty scary case. A child that runs and knocks over a laptop because she doesn't want to. Let's think about that. This isn't, you know, kids when they're young and they don't want to Skype and it's hard to get their attention. But how often do they just flee in fear because they don't want to Skype? Usually at this day and age, they're kind of engrossed and they like the cartoons and stuff and all the tablets and the Skyping and all that has to offer. But this child is, you're going to hear Grandpa testify that she's so terrified, did not want to go back. They had to like trick her to get in the car and take her to the airport. I would submit to the court that this is not normal. It's not normal, and I would also submit that Kelly Campbell, who's been doing this a while, and you know, has absolutely no reservations, that this child should not have visitation. And what that looks like as far as this court's order, I don't know, because Mom, right now, she just wants to get to the bottom of it, but she's in a quandary because she knows it's important that children have both parents in their lives, but you know what? She's not willing to have both the parents or the defendant in this child's life. It's going to be harmful to her. We want a healthy, emotionally and physically child. You're going to hear maternal grandmother testify that the things that come out of this child's mouth are just astounding, with no provocation, no, just out of the blue. So I would submit to the court that you have a young girl who is desperately trying to tell us something.
Okay.
And we need to listen.
Kind of a long opening statement,
Oh, I'm
but
sorry,
yeah.
Your Honor.
We want to get to your first witness.
I do. I want to call Kelly Campbell. Sorry, Your
How
Honor.
many minutes was that? What time she fucking?
We call him Kelly.
I'll make sure
Yes.
Mr. Jacks doesn't go over her stated time limit.
How much did she go?
20 minutes.
20?
Wasn't it?
Hopefully you won't take 20. Average is about 10.
Oh, really?
10 minutes, yes. A lot of it's usually taken up in closing, which is, that's fine though. Very
Sorry.
good. I got the highlights. Okay.
Oh.
Okay, we'll have the witness sworn in.
Please raise your right hand. Do you solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
All right, you may be seated. Thank you. Miss Mars, your witness.
Hello, Miss Campbell, and thank you for joining us today.
You're welcome.
We'll try and get you in and out. I know everybody's had a long day, including the judge and everyone else in the courtroom. So, can you state and spell your name for me?
Kelly M. Campbell, Kelley, Mcampbell.
Okay. And how long have you lived in Nevada?
In Nevada? 28, 29 years?
Oh, okay. That makes you needed.
Yeah.
Okay. And can you tell me, give me a little bit describe your educational background.
I have a bachelor's degree. I also have a graduate degree from the University of Nevada, Las Vegas in social work. And then I went on from there to complete a very, very difficult and lengthy clinical internship. I had to take several exams. During that process, I worked in psychiatric hospitals with psychiatrists, nurses, patients, and then when I was completed with all of my hours, I had to take a very strenuous exam and pass that to become fully licensed as a licensed clinical social worker.
LCSW.
LCSW, yes. And since that time, I have been doing it for so long. I am now a supervisor for clinical interns. So I supervise those that are in training as well.
What's your bachelor's degree in? I'm sorry.
It's in human development and family studies.
Okay, that's interesting.
Says you're a credential LCSW MA.
A master's degree,
Yeah.
yeah, and then a licensed clinical social worker.
LCSW.
Mm-hmm.
And then you have an MA after that?
Master's in arts.
Master's in
Yes.
Arts. Okay.
Yes, ma'am.
And where did you obtain your bachelor's degree from?
UNR.
UNR.
Reno.
Wolfpack.
Yes, I know, and now I'm a rebel. Sorry.
Okay. And so how long have you been in the field where you've been a therapist for patients?
Golly. More than 10 years. I'd say about 12 years.
Okay.
But I've been working with children and families for over 20.
Okay. And how is that through your training, or is that through, how is that 20 years?
Well, once I got my bachelor's degree, then I worked with children. I worked in child development, so I worked with very small children. Yeah, and then I went on to get my master's degree and then get my clinical licensure, and then through that process I worked in psych hospitals and in outpatient clinics and so forth.
Okay. How young is the youngest child that you've ever treated?
3.
3?
Mm-hmm.
Okay. Would that be the child at issue in this case, Charlotte?
Oh
or
no, I've worked with many children, but 3 is the youngest.
3 is the
I've worked with several 3-year-olds, 4-year-olds, 5-year-olds, all of it, all the way up to geriatrics.
Okay. Have you ever had children as patients that had these types of issues, specifically allegations of sexual abuse?
Many times.
Okay. How often would you say?
I don't know if I could count the number of cases, more than 50.
Okay. Do you have any sort of special training that would help you in not only diagnosing these types of cases, but the result in therapy?
Yes, of course. We're required annually to complete, CEUs, which are basically continuing education units. So not only am I required to attend a variety of trainings, but I have intentionally sought out additional trainings to work with children and to understand play therapy is one, trauma focused, right? So I've done specific trainings in trauma focused, play therapy, working with little kids, and then victims of crime, so just a lot of trauma-based stuff. And then I've done a lot of specialized training working with psychotic patients.
Okay. Like 3-year-olds or?
I've never seen a 3-year-old with psychosis, but the youngest I've seen is like 7 or 8, which is very rare, but it has happened.
Okay. All right. So, there came a point in time where you, first saw the child, in this case, Charlotte.
Yes.
Okay. And do you recall what date that was?
If you don't mind me referring back to my notes.
Oh, and
I
I'm
will-
sorry,
That's
let me, yeah, if you can, do you have the notebooks in front of you?
Oh, this right here?
Yeah.
I do.
Okay.
Maybe that would help me.
Yeah, and, may I approach the witness, Cheryl?
You may approach.
At the bottom of these.
I believe it was almost a year ago, but
Okay, this is, this is the wrong notebook.
okay,
Do
that's
we
okay.
have-
I've got it in here.
Well, wait, we've got a notebook for you.
You need plaintiffs?
Yes.
Should be,
What, is there a specific?
There's two, there should be numbered 1 and 2. Sorry.
No, so I just need to look for the initial assessments that I did, and that would be the damage.
Yeah, don't hurt yourself, they're heavy. Sorry. They are heavy, aren't they?
yeah, one hand.
I know, you're showing off. You're jealous. Just right here.
Oh,
So we're gonna look at these notebooks,
perfect.
and I want you to disregard the tabs.
Okay.
Okay, I just want you to look at the number
Mhm.
on the bottom,
Okay.
okay? It's called a Bates stamp,
Okay.
so it's a long story about the tabs, so we'll look at that. There's 2 volumes here, 1 and 2, and I think primarily you are going to be in dealing with volume number 1, okay?
All right.
Okay, so, if you'll turn to Bates stamp number, court's indulgence, 201, at the very bottom and right-hand side. Let me know when you find that.
Should be an exhibit number though.
It would be exhibit number, it should be exhibit number 49.
Thank you.
The operative word being should.
Can you confirm that? Ms.
Yes, there it is.
Okay.
Okay, yes, so the date I first met
201.
Charlotte was August 13th.
I see your exhibits are all mixed up, but the Bates numbers are absolutely chronological.
Yes.
Go to Bates 201 and it should be behind exhibit 49. Confirm that. I could work with that.
Okay.
But, for purposes of the clerk, you're gonna drive her nuts because
I
she's
know,
gotta
I'm
put
so sorry.
stickers at the end of them. But, you follow? It's all Bates 1, 2, last number, but her exhibit numbers are not in order. But exhibit 49, Bates 201. Okay. Just so you lawyers know, I don't look at anything unless it's admitted.
Yes, so the date that I first met Miss Charlotte was August 13th, 2018.
Okay, and maybe just as a housekeeping matter, I'd like you to look at pages 201 to 337, and I want you to tell me what these documents are.
Okay. Well, the first is an initial evaluation in which Christina was present along with Charlotte.
Okay, are these documents that were prepared by you?
Yes, ma'am.
Okay, and I want you to look through them carefully.
Mm-hmm.
Are these documents prepared as a result of your sessions with Charlotte?
Yes.
Okay, and do you recognize the dates on these?
Yes.
Okay. I would move to admit.
I object to the code that contains lots of hearsay. not all of the records in there are actually from Ms. Campbell, and we need to go through these one page at a time.
We do. Is there more than one report, or is it completely written by Miss Campbell?
Tons.
There are some notes that were done by Erica, who was the psychosocial rehabilitation worker that was assigned to work with Charlotte. So there could be some of those in here. But the ones I'm looking at as I was speaking, Mr. Jacks, are from obviously me. But then, you know, if I move on, then yes, there are some from Erica and so forth, because Erica did see Charlotte. Some of these are emails back and forth between Christina and myself.
Okay.
Can you tell me,
Your Honor, before we get to that,
Oh.
next question, can we find out who her patient is? Because I don't want her hiding behind privilege when she speaks to me. I need
In
to know,
terms of, what do you mean?
is her client the child, or is the client mom?
The
I
patient,
don't want her hiding behind privilege and speaking with me after she gets her testimony.
You want to respond to that?
well,
Did Mom sign any kind of HIPAA release for Miss Campbell to testify as to, unless they meet, I'm not even sure, are they invoking privilege?
yeah, I'm
I just
not
don't want
quite
it to
sure
be
what.
an issue later, Your Honor, after her testimony is out.
Typically what we do is if she is a treating, and not for litigation purposes, treating confidential, always confidential, remains confidential, unless, I guess, the parents would stipulate or sign a HIPAA release to allow her to disclose her client, even though her client is three and a half years old. It would be the guardian to make that call to disclose the confidential. So I'm assuming she has the consent to talk about the treatment of the client. And because this is a minor child, obviously it's not an adult, but the minor child is under the purview of the guardian. And right now that guardian is, dad has obviously no interaction or involvement in this part, so we will go to wait in terms of mom being the guardian, mom giving the HIPAA release to disclose and testify as to things, either the child, her experiences with the child. But I will say, just in the beginning of the trial, that we do have a child hearsay rule that I do follow, unless there's an exception, excited utterance, or statements made for the purposes of medical treatment or diagnosis. So that's going to be kind of hairy, but we'll get through it at that point. On these medical records, only as to reports, so it's limited, sustained, but I will allow in anything that she authored, because the author is available here to be cross-examined, unless there's meets any other hearsay rule. But I don't think these are business records, they're medical records. Anything that she authored on a particular Bates number, sure, she's allowed, they would be admitted, because she's allowed to be cross-examined on that.
Okay,
If there's an Erica lady, unless you call in the Erica lady
we will.
as to her notes, then, and you listed her as a witness?
Yes,
Okay, so only author-specific documents then?
okay, we'll go through them, and they're not that many.
Yeah,
Okay,
just the relevant pages that you want the court to look at.
Sure.
I'll just put tabs on them.
okay.
You have a
Thank
white
you, Your Honor.
Post-its? Big fat Post-its. Oh, really? Sorry. White Post-its. Okay. Keep this together, I will still keep my notes together. Okay.
Yeah.
So where were we, on Bates 201?
Okay, we're on date stamp 201
Through- Through, if she's the author, it's submitted. So,
201,
and she says most of these are her.
date stamp 201 to
206,
206, yes. Your
unless
Honor.
that's, the behind it isn't a,
They're different days, Your Honor, you don't want to take these one at a time.
different, entries.
201 and 206.
It would save a lot of time if her name is on here. And if she's the author of all this range of documents.
Yeah, and if you'll turn to page 206 at the bottom of that, it says electronically signed by Kelly Campbell, is that you?
Yes.
Okay.
So we're only dealing with that range of pages first?
Correct.
Okay, page 2.
Thank you, Your Honor.
Overruled as to the objection.
Okay, can you tell me about
01 to
this?
06 is 201 to 206. I mean.
Can you tell me about this report, why you put what you put in it? Just tell me about your initial meeting with Charlotte, any concerns that you had on this particular day.
So during an initial evaluation, the parent and the patient are always present. The patient is Charlotte. The parent is Christina. You want to gather historical information as much as you possibly can. So I would say to Mom, okay, tell me why you're here. What are your concerns and what's going on? Okay? And so she presented with her biological mother. Mom reported that she had moved to Las Vegas from Buffalo for the purpose of getting away from Mr. Osborne. And then she talks about the relationship that she had with Mr. Osborne. That was relevant based on what continues to be reported here. Because Dad said things that kind of gave Mom red flags when she was first meeting him, dating him, and became pregnant. He said things here about, our daughter's going to be so hot. She's a girl. She's going to be so hot. That's obviously very concerning. As a therapist, to hear that a father would say that about an unborn baby, red flag. And it goes on to the history of the abuse that Mr. Osborne did to Christina, the mother. And that he was also at one point, I believe it was dismissed, but he was convicted of statutory rape. So, okay, so I know that he's got a history here. And
What does that tell you, the statutory rape charge? What does that tell you?
that tells me he has a history of inappropriate sexual behavior.
Okay.
It's pretty clear. And then it goes on to, okay, now I understand why you're here. You're concerned about these things that are happening that you're not used to seeing in your daughter. And they started talking about the Skypes and how Charlotte would say, I don't love you, and I don't want to Skype, and things like that. So Mom's goal for therapy was just to make sure that her development is okay. That's what she wanted to do, was initial evaluation. Is this normal? What's going on with my daughter, right? And then I want to find out where she was born, where she lives, who she lives with, any significant events that occur. And she witnessed violent acts of Dad towards Mom. The separation of Mom and Dad, that's a significant life event. And moving on to the next page, the move to Las Vegas. And there was one time when the Dad, according to the Mom, kidnapped Charlotte. And so that would be a significant life event, right? Goes on to family history. I want to know, because there's always genetic factors when it comes to diagnostics, right? I want to know, is there a history of anxiety, depression, schizoaffective, schizophrenia, drug and alcohol abuse, poor behavior? Give me the full picture. I want the meat. I want the history. Dad had a history of substance abuse, excessive alcohol in his family. There was a grandmother that was a hoarder. Dad has anxiety. It was undiagnosed, but it was reported that Dad possibly had bipolar disorder. Not confirmed. That was just reported. We go on to discuss, the support. Does she have, is she in school? What are some good positive strengths? Sweet girl, friendly, loving. Current functioning, how's she doing?
Can I ask you, as part of that family history, did you come to, or were you informed that at some point the defendant in this case had walked around in the home that he was sharing with,
Injection leading around.
Let's shorten it a little bit,
that he
sustained.
had walked around naked in front of his mother?
I was sustained, so you have to rephrase it, it's kind of a long one.
All right,
Okay.
did you become aware of any,
Objection.
Overall, we
did
just
you
first
become
find
aware
out if she's aware.
of any other oddities with respect to sexual behavior?
Yes,
What would those have been at that
walking
point?
around naked in front of his mother. Yes, that's very bizarre.
Okay, all right. Does
As
any-
a minor, as a child, or as an adult?
No, the Aaron Osborne, I was told that Aaron Osborne walked around naked in front of his mother. As a clinician, yes,
As in,
that is a bizarre behavior.
well, when he was 3 years old, and when,
No,
or
no,
if
no,
he
when he
was
was in the-
25 years old, I don't know.
When he was an adult. I don't know his exact age.
As an adult.
Yes,
Okay, and you found that odd?
very.
Why?
It's inappropriate sexual behavior. You don't walk around in front of your mother naked. You're an adult. Put your clothes on.
Okay, all right. Did, were there certain things that Christina told you on that particular date that raised more flags with you? I would direct your attention to page 202.
Yes,
What were those?
naked hugs, bruises.
Back up, naked hugs between whom?
Mr. Osborne asked Charlotte or engaged in giving Charlotte hugs while she and or he were naked.
Objection foundation. Is this mom asking or is she getting this from the kid?
Charlotte. Charlotte said, Dad gives me naked hugs.
Did you ask Charlotte what that meant?
I asked how she felt. I don't like it. Of course she doesn't like
Sorry, I
it.
have to roll in the objection. So, foundation. Then she answered, she said Charlotte made the statements?
Yes.
Either child hearsay or statement for purposes
Well-
of medical treatment.
Not exactly, and not only that, but an excited utterance.
Decided if it's-
Overruled unexcited utterance, but I would sustain it on child hearsay, any other exceptions, for the purposes of medical treatment. Well, we're talking statements like, Doc, my arm hurts. That would be not hearsay. But the child is saying these things to the therapist, and it's hearsay at this point. How is it for medical treatment? And it's because
I would-
she is going through counseling treatment,
Absolutely,
but
Your Honor,
it's
her
for
mental
medical
health.
treatment.
Yeah, I could brief it if you want.
I would say so. Let me sustain it at this point right now. Not what the child said, but I will accept a topic about naked hugs between either the child being in the nude or dad being in the nude and their hugging goes on. I will take that as a topic that was explored, but not what the child actually said. So, and you can brief the statements for medical purposes also include mental health counseling. All right.
Your Honor, do you want to?
I'll accept right now that the topic of naked hugs between father and daughter were brought up. Oh, thank you. Okay. Neat. Okay. Put a tab on this one. Oh, that's some green tabs. I'll get them. Okay, next question.
Okay. Do you
All
want
right.
to brief on that, or do you want?
Might, because it might be a sticky issue with Mr.
Yeah, I think
Jackson.
it's
He'll
good
keep
to know.
raising the objections,
Okay.
so he may just speed up the trial if you have
Sure.
that.
I'll get you one.
Yeah, that one did come to mind, and I've been a judge a long time, so I've never seen that issue.
I'll get it briefed for you.
Okay, all right.
So, Ms. Campbell, based upon the child's response, and don't tell me what it was, did you become concerned?
Very much so.
Okay. And did you explore that concern?
Very much so.
Okay. And did you come to a conclusion?
I came to the conclusion that there was an adjustment disorder going on. Because in 1 hour, you have to be very careful that you have enough information to fully diagnose. A lot of times, it takes a while for you to get to your real diagnosis. Initially, there was definitely an adjustment disorder going on. Definitely.
Okay. And what do you mean by adjustment disorder?
It means that she was exhibiting behaviors that are out of the ordinary based on events that occurred.
Okay.
And that it was possibly a temporary thing.
Okay.
Adjustment.
So that's what you thought after exploring the topic of
Objection needed.
naked hugs?
Sustained, rephrase.
Okay. Based upon the, you just testified that the child was providing you with responses that troubled you. Okay. Do you think there could be more?
Oh, yeah, yeah.
Objection needed.
Do you think there could be more? First we'll see if she answers yes or no. Then
Yes.
the next question should not be leading. You think there's more
Yes.
to it? Okay, next.
Why?
Because it was explained that the patient was having not only discussed naked hugs, but was doing a lot of things that she had not done formerly. Wetting the bed. Having excessive tantrums, which she normally wouldn't do. She was fully potty trained and then started peeing herself all of a sudden. Became very clingy towards her mother. Scared of men out of nowhere, like she was never scared of men before, and now she is. When you put all of those things together, you come to a conclusion that something happened and this child has regressed. So there's an adjustment period. Let's see if she gets better with a little bit of therapeutic services.
Okay. And at that time, if you'll turn to page 202 at there's a large paragraph there, and the last line, what was mom's goal for therapy when she met you?
Was to make sure her development is okay.
Okay. Did she come in accusing anybody?
Objection needed.
Oh, overruled, that one's just preliminary. Doesn't really go to the heart. So see if she says yes or no.
I'm sorry, repeat the question?
Go ahead.
Did she come in making allegations or?
No.
Okay. Okay, if you'll, just looking through your notes here, on page 203.
Bake's number would be helpful. 202?
203,
Bake's 203?
yeah.
Oh, they said 2 of 3.
Oh, I'm sorry.
203.
203.
My bad. Okay. Go ahead.
Sorry. Do you see, this is part of your entire report, is that correct?
Yes, ma'am.
Okay. Current functioning.
Mm-hmm.
Tell me about how you came to this conclusion.
I came to the conclusion that she does not function well when she's with her dad based upon the mother's report and the patient's report. That there was significant regression in her functioning whenever she would return home from dad's place.
Now, did you and mom talk about dad in front of the child?
No. Christina was very, and I kind of guided her through this. When she would discuss Aaron, I gave her a clipboard and a piece of paper. I said, write it down. We don't talk about these adult issues in front of children. She'd write it down. I'd look at it. I'd read it. I would type, okay. And then I would, if it was something that I did not want Charlotte to hear, that's not appropriate for her to hear. No, Christina was very good about being very cautious what she said in front of her little girl.
Okay. Question? Did I sneeze? And then, date stamp number 205, if you'll turn to that page. Do you see where it says diagnosis?
Uh-huh.
Okay, now, you met with Charlotte, this was the initial diagnosis, correct?
Yes, ma'am.
Okay, why did you put risk of harm 3? First of all, what's the scale on a 1 to, is it 1 to 10, 1 to
5.
1 to 5?
Yeah.
Okay, and how did you come to that diagnosis?
How did I come to the diagnosis, or what?
The diagnosis that, like for instance, risk of harm.
Well, you're looking at two separate things here, okay? So what we have to do per Medicaid guidelines is an assessment called a CASI, which is basically a determination of level of functioning, okay? And there's several questions. Risk of harm 3. Yes, I felt there was significant potential risk for harm based on the fact that I knew Charlotte was going back to see her dad, and based on the information I was given in that initial assessment, that is a risk of harm. She's going back to see him. She's reported that he's hurt her. Yes, she's at risk for harm. The diagnosis is at the very bottom. The adjustment disorder with mixed disturbance of emotions and conduct, F4 3.25.
Where's that at?
At the very bottom of the CASI.
Okay.
Yeah.
Okay. And then problem 1 on that same page, what's that all about?
So this is a treatment plan, which you do. Now we actually, EHR is better, but back then, a year ago, we were doing it in the initial assessment. So at the very bottom, it says recommended treatment goals and plan. So per Medicaid guidelines, you have to have a plan of what you're going to do with the child going forward. The problem 1 was reaction to parental arguments and visitations with dad, right?
Okay.
So that was a problem. The problem 2 was separation anxiety.
Is that on page 206?
206, correct.
Okay.
That's all I could identify at that particular date.
Okay. And so what was your plan on that date of August 13th, 2018?
To work with the patient in helping her understand her emotions related to arguments between mom and dad, the confusing emotions about visiting dad, right? To get a child to understand what those feelings are. That's difficult with a 3-year-old, but that was the goal.
Did you reach any other conclusions or have any, anything that you were thinking about at the time that as to where maybe this particular case might go?
No, it took me a while to get, Charlotte went from the initial adjustment disorder, then I changed it to anxiety disorder unspecified because things were getting worse. Then I changed it to other specified trauma and stressor related disorder, F4 3.9, because things were getting worse, which is almost PTSD.
Okay. All right. So, Your Honor, I would move to admit pages 201 through 206.
Any objection? Okay, she's the author of that, so no objection, it's submitted 201 to 206. Can you give me those 3 changes that you made again? Adjustment disorder
Yes,
to...
ma'am. It started with the initial diagnosis was the adjustment disorder,
Then you
okay,
changed it
and then
to...
it changed to anxiety disorder unspecified, and then it was changed to other specified trauma and stressor related disorder. That's categorized by F4 3.9.
Other specified trauma and related disorders. And then...
Other specified trauma and stressor related disorder.
and
Correct.
stressor related disorders.
Yes, ma'am.
Did you get to the next level of PTSD?
No, because she was getting better.
Okay, thank you.
And we'll talk about that too. Let me ask you a question, because I know as attorneys, you know, somebody comes in our office and you have to remain objective. Do you ever, is that a common practice for you, or do you believe everything that like a parent would say?
No.
Okay. All right, so is it fair to say you keep an open mind in these cases, or?
Absolutely.
Okay, is that a requirement, is that something you're trained, or?
That's something I'm trained in. You can't always take everything the parent says as being the truth, because there's always more sides to the story.
Okay.
There's
And-
two parents, there's grandparents, there's the child. There's a lot of different perspectives.
Okay, and did you do that in this case, keep an open mind?
Yes.
Okay. All right, I would like to turn, you to turn, if you will, to page, Bates stamp 216. And 216, and if you'll look at those notes actually 217. Okay, do you recognize this document?
Yes.
And what is it?
It's a progress note.
I'm sorry?
A progress note.
Okay, and did you author it?
Yes.
Okay, and does this accurately depict what you would have authored?
Yes.
Your Honor, I would move to admit pages 216, 217.
Any objection? Just those two Bates numbers.
Your Honor, it's hearsay.
Anything compared to, well, if there's any child hearsay, we'll take that out. But,
Well,
according
it's
to
also
this, she's the
reports from
author.
mom as well, and so she's reporting what she's been told.
Yes, but she's available for cross-examination. All right, I'm gonna overrule it and allow 216, 17 to come in, over objection.
This would have been, now, she had a visit with you August 13th. When I say she, I mean Charlotte, is that correct?
On August 13th.
That was her initial visit, is that correct?
Oh yeah. Yes.
Okay, and then would this have been the second visit, the 9/6?
Correct.
Okay, and why the lapse in time?
My schedule was very full. It was as soon as she could get in.
Okay.
And
Um,
of course, there's always other therapists that are offered, but that was not the mother's preference.
Okay. Did you, were you aware that Charlotte had a visit between the first and second visit with you?
Yes.
Okay. All right. Do you know the date that Charlotte returned to, if you know, if you don't?
I don't.
I don't want you to guess.
Yeah,
You know,
I
let
don't.
me ask you something. So, after that first visit, you didn't have a problem with, Charlotte going back for her visit with her dad, is that correct?
Correct.
Objection, Your Honor, leading.
Sustained.
Okay. Did you have any concerns with,
Objection, reading.
Overruled because first let's see if she has any concerns.
after the
Finish
first
it.
visit, did you have any concerns with, any contact between Charlotte and the defendant?
After the visit?
After the very first visit?
Oh, when I did my initial assessment? No, I knew she was going to see Aaron, and I did not have any objections to that.
Okay.
No
And then
concerns.
as far as you became aware, you just testified that she did go back for a visit after you saw her, is that correct?
Correct.
Okay. All right, and so when you met with Charlotte the second time on September the 6th, 2018, was that following her visitation with the defendant?
Yes.
Okay. And tell me how that visit went. Was she making progress? Were things getting better, worse? How was it going?
Objection, she's leading.
Well, she
No,
can
they're
testify to her
objections.
notes.
Sustained, rephrase.
Okay. Did you have concerns at the second visit?
Yes.
Okay, what were they?
The patient had regressed significantly. The behaviors became very concerning. Nightmares, peeing the bed, acting like a baby. She pulled her panties aside and was looking at her vagina in the mirror. She talked about touching herself, touching her vagina, thinking it's funny. She stuck her butt up in the air with no panties on and said, "This is how I sleep at Dad's." All of that is a very, very concerning, all of it.
Okay. I was just gonna ask you, is that something like, because I know kids, you know, they go through phases of development, and I mean, is that something, wouldn't that be something just like normal for
No.
a phase?
No,
No?
no.
Okay. Alright, so what did you do, I mean, what kind of therapy did you do on that day, if any? Did you do therapy, or?
Mostly it was mom reporting what the behaviors were going on at home. And then of course, you know, I would always talk with Charlotte. How are you feeling? We would talk about emotions. But this particular visit, it was mostly mom reporting to me some of these things that were going on. And it led me to contact Children's Protective Services in New York.
Okay. Do you have an obligation to do that?
Yes, I am a mandated reporter.
Okay, what does that mean?
It means that if I suspect a child has been abused, either sexually, emotionally, or neglected by an adult, that I have to, by law, pick up the phone and call Children's Protective Services and report my concern.
Okay, and you said you called who?
I called Sarah Whitman, who is a CPS worker in New York,
Okay, why New York, why not Nevada?
because Aaron Osborne lived in New York.
Okay. Alright.
Then,
Did you speak to Sarah Whitman?
yes, I put in here that I would be contacting her, and then later on there is documentation. If you'll refer to page 220, I made the call on the 7th, so the following day I was able to contact. Unfortunately, I left a message, but I did my due diligence and I did call her. There is further documentation of actual verbal back and forth communication.
And we'll get to that. So, Your Honor, I would move to admit pages 216 to 217.
Already admitted it.
Oh, you did, I'm sorry. I would move to admit page 220 then.
220. Any objection to 220? This is her note, Ms. Campbell's note.
No, Your Honor.
All right, no objection, it's admitted.
Okay, and then page, if you look at Bates stamp 221, is this a report that's authored by you?
Yes,
Okay, and what is the, why was that note authored? What's this all about?
this is when I actually spoke with the worker, Sarah Whitman, in New York. And Sarah had reported that there was an open investigation on Aaron, and that I told her I was concerned about her going to visit, about Charlotte going to visit her dad in October. And I wrote down here, intentionally, I typed in here what was instructed by Sarah Whitman, who was a CPS worker in New York. She said,
Objection, lady, hearsay.
Can't tell me what she said.
Based upon your conversation with Whitman, Ms. Whitman, did you determine that Charlotte should not return to New York for a visit?
yes,
Okay. And did you put that in this report?
yes,
Okay. And is that kind of a CYA for you?
yes.
Okay.
Can we back up a second? When you said that there already was an open investigation, you learned from making the contact that there was already an open investigation by the time you made your mandatory report?
Yes, ma'am.
Okay, thank you.
Do you know what that open investigation was for? Or did you come to learn what that investigation was for?
Yes. Sarah told me that it was,
Objection. You're
What
I
did
think
you
that
tell-
would be sustained as to hearsay.
You can tell me what you learned.
I learned that someone had,
Objection is
I
coming-
think
that is
that's
coming from hearsay.
sustained as well, because she learned it from hearsay. I'll accept that she found out by the time she made her mandatory reporter call that there was another New York CPS open investigation. Now, I won't be able, you can figure out later if you can try to get in those details, but I accept that there was an open investigation.
Let me ask you
Okay.
a question. Was that a result of you calling in the day prior, or was that something
Objection,
else?
meeting.
If you
Aston
know.
answered, I'll sustained.
Okay.
Aston answered. It was already open by the time she called hers in. Okay.
Okay, was 221 admitted, Your Honor?
We were on 220. I thought you were working on 220.
Yeah, I would move to admit pages 220 and then 221.
The objection, Mr. Jacks? This is her notes.
It's got hearsay in it,
Except for any hearsay
except for.
from
hearsay.
from Sarah Whitman?
Yes,
All right, conditional, no objection, except sustained as to any hearsay from Sarah Whitman, because she's not available unless she testifies later. She's a listed witness. Monday, Tuesday.
Okay, and can you turn your attention to bait stamp 222, please? Do you recognize that document?
yes,
Okay, what is this?
this is another Children's Protective Services report made by myself.
Okay, and who did you call?
The local authorities here in Las Vegas,
Oh, okay, and why did you call them?
to cover all grounds to protect this child.
Okay. Your Honor, I move to admit 222, please.
No objection.
No objections admitted, 222. Thank you.
Now, do you see on page 223 and 224, what is that specifically?
This is an email between myself and Sarah Whitman.
Okay, and why did you send an email to Ms. Whitman?
She asked me to.
Okay, and what did you tell Ms. Whitman in the email?
Objection, hearsay.
She could testify what she told another person. She
Not if
told
it's-
him.
Not if you're doing incorrect, it is.
What did she tell you? That would be hearsay.
Yeah, well,
Sustained.
not what Sarah told you. What did you tell Sarah?
Oh, what does the,
Yeah,
she's
yeah,
the
yeah.
declare overruled if she's the one talking.
Yeah, what did you tell Sarah?
I told Sarah what happened in session with Charlotte. I told her that Charlotte had said, Daddy told me not to tell about the naked
Your Honor,
movies.
she's reading the document instead of actually testifying about her
Mhm.
personal knowledge. I object to her being able to do that in that fashion. If she wants to tell us what she has to say, what she said, she's more than welcome. She needs that document to refresh her memory. But until it is put into evidence, Your Honor, she's not supposed to be looking at the document to be able to read from it.
Okay. There's a difference at trial, so unless she's directed to refer to something in the exhibit notebook, then I guess she will not look down at any of the notebook documents.
Okay, if you want to refresh your memory as to what you told Sarah Whitman and why,
Yeah.
can you look at that and don't read it verbatim in court, but refresh your memory and you can let everyone know what you told Sarah and why you told that to her?
Sarah asked me to send an email because she needed it in writing for her case, and she wanted to know what my concern was with Charlotte. And I told her my concern was some of the things that Charlotte had said to me in session and some of the things that were going on.
Okay, what were your concerns?
Charlotte had told me that
Objection, Your Honor.
What were your concerns?
Sustain the hearsay.
Charlotte should not see her dad. I was concerned that she had been sexually molested by her father.
Okay. And you authored these emails on 223 and 223 and 224. I'm sorry, Your Honor. Is that correct?
Yes.
Okay. Your Honor, I'd move to admit 223 and 224. Sorry, I can't talk.
And you
Yes, Your Honor.
okay, what's the basis for the objection?
The objection is it's hearsay, Your Honor. It was also done just for the purposes, like she said, of litigation. So, being that it's hearsay, I mean, hearsay is a statement other than the one made by
From the
defendant.
child?
No, this is of her own statement, Your Honor. She wrote an email and she wants to admit it into evidence. She can't do that under the hearsay rules.
That's not what 23 and 24 is it?
Yeah,
Yeah,
the
no,
223
it's not. It's an email from the witness to another party. She can certainly
Her own
testify.
words. Okay, I will sustain it as to any hearsay contained in the email. Otherwise, it's admitted. I'll accept she sent an email to Sarah Whitman on 9/13/18 at 12:58 p.m. But there are sentences in there I see that says, what did the child say? And then what the child said was hearsay, which I cannot give any weight to. So for purposes of showing that she wrote an email to Sarah Whitman, but any references to child hearsay statements will not be considered by the court.
And Your Honor, in
It was
that regard,
objected to and it was partially granted. It's admitted, conditionally admitted.
And
Admitted only without the hearsay.
I know I said I'm going to provide you with a trial brief in that regard because there is case law. I've actually attached it to my pretrial memorandum, but I'll get you some California law because I couldn't find any in Nevada as far as.
The only thing I've known to admit is our FMC child interview reports.
Yeah. But I mean, like with children's statements and as far as them being.
You guys may have to
not
brief
hearsay.
that one.
Okay,
Okay.
I'll brief it for you.
Okay.
Okay. So, Ms. Campbell, sorry. Now, I can't, on pages 225, 226, 227, 228, 229, 30, 31, 32, can you tell me what this is because I cannot. What is on these pages?
111, 223 to 224.
Christina
Previously.
gave me
23.
legal documents that she had, and I uploaded them into EHR, and they're very blurry. I apologize, I don't know what they say, but she gave me copies, and anytime I receive anything from a family member or a patient, I always put it into the system. It just came out very blurry. It's some kind of a legal form. It might have been the guardianship, or the decree or what have you.
From New York?
Yeah, but I can't tell what it is. I'm sorry.
Okay. So that was the document provided by the plaintiff to
Yes.
you?
Correct.
Okay. And that's part of your record?
Yes.
Okay. And would that be the same for pages Bate stamp 234 and 235 as well?
Yes.
Okay. And,
Oh my God.
okay. If you'll turn to page 236, if you'll review that, 236, 237, 238. Is this a report by you?
Yes,
Okay. And when did you author this report?
September 20th, 2018.
Okay. And what is this report from?
This is a follow-up session.
With who?
Charlotte,
Okay. And what was your assessment on that day?
that the patient had regressed even further.
How so?
More nightmares, more wedding, more triggers. Things were starting to trigger her. They were Skyping, and then the word Skype became a trigger. Other triggers would be men, the bathtub. She refused to sleep in her own bed, which she formerly slept in her own bed. Clinginess, aggressive behavior out of the ordinary for Charlotte. Again, further touching and exploring of her privates that was bizarre in nature. It's further regression. She even pooped herself.
Okay, did she do that when she was in your office?
No.
Okay. Okay, and what did this regression, what did you conclude as a result of this?
That she was sexually molested by her father.
Okay, was it something in particular, or was it?
Everything put together. I've been doing this long enough, I know exactly what the signs are. And everything Charlotte stated, everything that she was doing and behaving, all of those things, when you put it all together, it leads to one conclusion.
Okay. You've had cases like this before?
Oh yes, I've testified for several. One recently in Colorado.
Okay. And so, what did you tell Mom at that point? This is September 20th, 2018. Was Charlotte supposed to go back to see the defendant again for another visitation?
No, that had stopped.
Okay. Why had it stopped?
Because Sarah Whitman, the CPS worker in New York, told
Objection.
Okay.
You're-
Sustain as to any hearsay
Okay.
anticipated.
Did you learn at some point in time, and don't tell me how, but did you learn at some point in time
Objection, Your Honor, leading. Did you learn something
that the
at time?
visitation had stopped?
About what, if anything?
I'll see, overall, see if she answered yes or no.
yes, I learned that the visitation had stopped, yes.
She can certainly testify to what her knowledge is regarding.
Oh, the
visitation.
basis for the knowledge of why she learned that.
Again, it's just leading, Your Honor, takes you yes and then blah, 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 is what it is.
She didn't say
And so-
anything else, she said yes.
She said yes and then followed it by the entire sentence.
Not now, she didn't. I didn't hear her say anything, but yes.
Rephrase that, what was the original question you asked, so I'm clear and we have a record?
At some point in time, did you become aware that the visitations with the defendant had stopped, had stopped?
Yes.
And she's followed it up with a sentence after that.
There's a
And
sentence.
That
Okay.
one, she said yes, it is.
Did she become aware, okay, yes, but, the next question, how did she become aware, would obviously be, might potentially be hearsay.
No, I didn't ask her that.
Yeah, unless it was from
She
a,
said yes and then made a statement as to how she did.
we'll stop it at the yes then.
Thank you.
Sustained as to anything after the yes.
What, the cessation of visitation, was that because of the plaintiff?
No.
Objection,
Okay.
leading.
If you know.
Sustained. I'll disregard.
Did Mom have anything to do with the cessation of visitation, if you know?
Objection, leading.
She knows, that's not, she
Overruled.
either did or she I mean,
Well, her knowledge of whether it was due to mom or not could be hearsay as well.
well, if she,
But if it's statement by a party, that party is available to be cross-examined, so, no, I will overrule that one.
What do you mean?
The question about whether it was mom's doing. Unless you can take it up on cross-examination, how she found out that information, why she believes it wasn't mom's doing.
So I'm allowed to answer the question?
I think you've answered it already.
yeah,
Okay.
Go ahead, you can repeat your answer.
No.
Visitation stopped because of mom or something else? I
Something
guess.
else.
Something else, I gotcha, okay.
thank you.
Alright.
Okay, I would, is there anything else significant about, your therapy on that date, September 20th, 2018? Did you have a game plan?
At that point, my game plan was to keep her away from her father, keep her safe, help her express her feelings about what had happened, help her express how she was, coping, help her learn some new skills, to get better, because she was not doing well on that day.
And you said not doing well on that day. Did anything specific happen while she was in therapy with you?
She made several statements.
And did you become concerned regarding those statements?
Yes.
Your Honor, I would move to admit pages 236 through 238.
236 to 238, objection?
Yes, Your Honor.
Object to this?
Yep, hearsay, tons of it inside of this using direct quotes.
Oh, hang on a second. 236.
This will all be moved after my trial brief, Your Honor.
So it's qualified, sort of limited, overruled onto the fact that she wrote this progress note, and I'll sustain it right now on the child hearsay statements.
Okay.
Your Honor, I think that the thing is to see, is the child, mom is reporting something that the child says, and I got hearsay twice, to her it's not 3 times, that's the problem. It's not just hearsay within hearsay, it's hearsay within hearsay within hearsay.
I don't know how you're counting that, but she's having a session with the child. The child makes a statement, which I'm keeping out unless there's a rule in Nevada that says they're allowed to come in. And she's the author of that note, so everything else but the child's statements obviously can come in. So basically you're offering the document for the truth of the matter asserted, and the fact that this will acknowledge there was a visit on September 20th, 2018, and that the visit was between the child and the therapist, and she made treatment plans at that point in time, teach this child new skills for coping, and stuff like that.
And had
So-
also had grave concerns regarding, I think,
She actually recommended to keep child away from the father. So that's not child hearsay stuff. This is stuff she did in her line of work, I guess.
okay.
Okay, so right now it's still a qualified admission, only to show the date of the visit and what her plans were. Child statements that will have to be briefed.
236 through 238.
Yes.
Okay, if you can turn to page 242, please. Bait stamp, sorry. At the bottom of that page is what is this exactly? Can you tell me, is this,
This is an email between Christina and myself.
okay, did you write this email?
Yes.
Okay. this email to Christina is based upon what?
Videos that she sent me of Charlotte Skyping with her dad.
Okay. And was there an assertion made by the defendant regarding that Skype?
I'm sorry?
Strike that.
Okay, email.
What was this email in response to?
There-
Without reading it, you can. 'Cause
Well, okay, I'm trying to go off memory, but there was a Skype in which Charlotte didn't want to interact with her dad. Okay, so she was like climbing under the table, and she wouldn't interact with him, and he was like trying. He's like, Charlotte, Charlotte, Charlotte. He was trying, and she wouldn't do it. And so Christina in the video was going, "Come on, Charlotte, sit up." Like she was trying to help Charlotte engage with her dad. And the email was about me confirming with Christina that no, she wasn't interrupting or being disrespectful. She was actually helpful in trying to get Charlotte some time with her dad.
Okay.
That's it.
And you saw that video?
Yes.
Okay. All right, Your Honor, I would move to admit Bates 242, please.
242, any objection?
Yes, Your Honor.
What's the objection?
Well, Your Honor, okay, wait, give me a second.
Oh,
It's an incomplete record.
incomplete. There's another surrounding emails, but
It appear, I mean, this goes from something that allegedly came from, what looks like my client,
I could sustain it on
Oh.
child hearsay,
and
subject to briefing, but,
There-
I accept that mom emailed Kelly on September
it
21st.
looks like it was forwarded.
And also, it was forwarded from Aaron to whomever, to Christina, and so he's gonna be available later at trial to be
Yeah,
questioned as to his email. So,
I
overall,
would,
it will come in to show that emails were sent. Sustained as to anything Charlotte said, any of those statements, even if it was in Dad's email, I think. Yeah. And also I find it's relevant as to their co-parenting.
it's not the best evidence, Your Honor, I have a video.
Oh, great, that might be good for rebuttal purposes or for cross-examination purposes. Okay.
We have lots of videos too, Your Honor. I know you're excited.
Let's go. Moving on. By the way, how's everybody doing? They okay?
You know what, can we take?
Yeah, I don't wanna hold anybody hostage to their